I'm sharing my screen. Okay, is it visible, everyone?
Yes, ma'am.
Okay. So yesterday we talked about fundamental rights. Now there are some fundamental duties we should aware of and follow and obey those things. So our constitution has explicitly laid down certain fundamental duties of citizens in Article 51A. So in 51A article, fundamental duties are mentioned and emphasizing that every Indian citizen would promote harmony, spirit of common brotherhood, transcending religious, linguistic, and regional or sectoral diversities. Then, second is renounce practices derogatory to the dignity of women. Then, value and preserve the rich heritage of our composite culture, because we are in state or in a nation where there are, after a few kilometers, there is change in language, there is change in culture, food habits, traditions. So we have to respect and preserve those heritage and protect and improve the natural environment. We should be, aware of and do certain things to preserve our environment, natural uh, state, natural things around us, and develop scientific temper also at the same time, and adjure violence and strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to a higher levels of endeavor and achievements. So, uh, going forward and seeing ourselves at a higher position. But in addition, we have to take care of what our duties are towards our nation, towards our environment, towards the every other being in our nation, or the things around us. So the first citizen of India is the President of India. Let's see what the qualification required to be a president. So the first is he or she should be citizen of India, completed 35 years of age. So minimum age is 35 years, and then eligible to be member of LokSabha, and must not hold any government post except the following posts. He or she may be president earlier or vice president, maybe governor of any state, minister of union or any state. So he or she is eligible for the president, to be a president. Now, election, the president is indirectly elected through the electoral college, consisting of elected members of both the houses of the parliament, Lok Sabha and RajyaSabha, and the elected members of the legislative assemblies of the state, um, if there is no nominated members among them. And then the Supreme Court inquires all the disputes regarding the president's election. And the elected president take oath in presence of the Chief Justice of India, or in his absence, the senior most judge of the Supreme Court can do this duty. Then terms and emoluments. The terms are that this is a 5-year term here, and Article 57 says that there is no upper limit on the number of times a person can become a president. It is not restricted, like many times or more than 2, 3, as the electoral boards elected him or her, he can be or she can be a president, and can give his or her resignation to the vice president before full term. He may give or surrender his duties or her duties before his term over, before the vice president. Then impeachment. Now, quasi-judicial procedure can be impeached only on the grounds of violation of the constitution. If there is anything against the constitution, then there should be an impeachment. And this procedure can be initiated in both the houses of the parliament. Then vacancy in case if the office of the president falls vacant due to death or resignation or removal, then the vice president acts as a president, or you can say a joint president. And if he is not available, then the chief justice. And if chief justice is not, then the senior most judge of the Supreme Court shall act as a president of India for the time being. Now, the election is to be held within 6 months from the date of vacancy. Now, what are the powers of a president? Appoints the PM, ministers, then Chief Justice, and judges of Supreme Court, High Court, chairman and member of UPSC, controller and auditor general, and he can appoint attorney general, chief election commissioner, and other members of election commission of India, then governors of various states, then member of finance commission, ambassadors, and so on. And then summon or prorogue the session of two houses and can dissolve the LokSabha, appoints the finance commission. After every 5 years, he can appoint, and that recommends the distribution of taxes between the union and state government. Then Supreme Commander of the Defense Forces of India, chiefs of Army, Navy, and Air Force, and he can declare wars and conclude peace to the approval of the Parliament. Now, no money bill or demand for grant can be introduced or moved in the Parliament unless it has been recommended by the President. And he has the power to grant pardon or reprieve or remit punishment or commute death sentences. So he can exempt those punishment, and he can he has that power. And emergency powers are also there. 3 types of emergency he can or she can declare. The president can declare national emergencies under the Article 352. There are certain conditions, certain situations. Under those conditions, president can declare the emergency. Then state emergency that we call president's rule under Article 356. Then financial emergencies under Article 360. The next prime position is Prime Minister of India, and Prime Minister is the real executive authority because he is in charge of all the laws, policies, administration. Directly, this post is very much important. So he is the ex officio chairman of the National Institution for Transforming India, like NITI Ayog. While earlier it was Planning Commission, then National Development Council, National Integration Council, and Interstate Council. Now the president convenes and prorogues all the sessions of parliament in consultation with the prime minister. So he can recommend the dissolution of Lok Sabha before expiry. So he has that authority, the prime minister, and he appoints all the ministers, council of ministers, and he allocates portfolio, and he can ask the minister to resign and can get him dismissed by the president. So the primary concern is of prime minister, and he has the power to recommend to the president to declare emergency on grounds of war or some external aggression or armed rebellion. And in such conditions, he can recommend to the president. So finally president has the power to declare that condition. And he advises the president about the president rule in a particular state, or in case of emergency due to financial instability. So he is the leader of the house. Then vice president election, vice president elected by both the houses. in accordance with the system of proportional representation by means of a single transferable vote, and this vote being secret. And nominated members can also participate in his election. The Supreme Court has the final and exclusive jurisdiction for resolving, disputes and doubts relating to the election of the Vice President of India. The criteria, age, and eligibility are more or less same. Eligibility that he or she possesses the qualification for a membership of RajyaSabha. And all are, I think, same. Does not hold any office of profit in the union, state, or local authority. And for this purpose, the president, vice president, governor, and minister of union or state are not held to be holding an office of profit. This is all about the same. Then the next topic is citizenship. Now, citizenship of a nation is a person who enjoys full civil and political rights in that nation. And the aliens are the people who do not enjoy all these rights. So we call them, foreigners or the other people, not belonging to that particular country or India. Now, rights available to a citizen, what are the rights? So there are rights we have already discussed. And the right to not be discriminated against on the ground of uh, religion, race, caste, sex, or place of the birth. And the right to equality of opportunity in matters of public employment. So everyone is eligible according to that particular post or any particular, status. There is equality, not on the basis of caste or sex or race. The right to the sixth freedom of Article 19, namely right to speech, right to assembly, right to association, right to movement, residence, and occupation. So you can live wherever you want. You can move from one place to another. You can be associated to a particular firm or particular religion. So all these freedoms are given under the Article 19 of our Constitution. Then cultural and educational right. You can educate yourself. You can always go for qualification rise in your particular field of interest. Now, the right to vote for election to the parliament and legislative assembly of the states, you are having that right. And certain offices, for example, the president, prime minister, vice president, and judges of the Supreme Court, High Court can be occupied only by Indian citizens. This is the mandatory condition. Now, the right to equality before law and equal protection of the law, then right to protection of life and personal liberty and right to freedom of religion are available to aliens also. There are a few rights which are available for foreigners, which who belongs to the other countries. Now, there are two types of citizenship, single and dual. But India has single citizenship. It means that a person can be only a citizen of India, not of any of the states of India. And also, the Indian constitution forbids dual citizenship, whereby a person may be a citizen of two countries at different countries at the same time, or of a country or and one of its units or states at the same time. So a person can only be citizen of India and claim the rights and privileges that go with the citizenship. Now, who are the citizens of India? Constitutional provisions are there, and there are certain classes of people who would be considered citizen of India at the time of commencement of the constitution. There are citizens by domicile, means those who live in India and fulfill any one of the following conditions, namely they were born in India, or their parents were born in India, and they must have lived in India for at least 5 years before the commencement of the constitution. So before 1950, or before independence, if they lived here for 5 years, then they can apply for the registration, and they are called the citizens by domicile. Then migrants from Pakistan to India. Now, if there are migrants from Pakistan to India, are to be considered Indian citizens if they or their parents were born in undivided India, means before independence, if such conditions were there. And migrants from India to Pakistan, any person who migrated to Pakistan after 1st March of 1947 ceases to be the citizen of India. And the people of Indian origin residing outside India, they are also considered as citizens, but their parents or grandparents were born in undivided India, and they can claim the citizen by registering themselves as a citizen with the diplomatic representatives of India at their country. Now, what is the Citizenship Act? So, this Parliament passed the Citizenship Act 1955 and Citizenship Amendment Act in 2003, laying down ways in which a person may acquire or lose Indian citizenship. So, according to these acts, a person may become a citizen of India, as we have seen just now, by birth, by descent, by registration, by naturalization, or by incorporation of a territory. Now, a person who lived in India or has served the government of India for at least 7 years, knows one of the official language of India, has renounced the citizenship of his country of origin, and has taken the oath of allegiance of India and is of a good character. They can also apply for citizenship through naturalization. Loss of citizenship. Now, what are the conditions under which a person can lose his or her citizenship? So, first is renunciation. All Indian citizens can make a declaration of renouncing his citizenship and have this declaration registered. And the second is termination. When a person becomes a citizen of another country voluntarily, then he automatically loses his citizenship of India, because in India, single citizenship criteria is there in constitution. And then deprivation. A person who becomes a citizen of India by naturalization or registration can be deprived of his citizenship if found that he gained it through false means and showed disrespect to the Indian constitution, or was disloyal to the country, or some activities which are offensive within 5 years of getting the citizenship. And the Citizenship Amendment Act of 2003 also made it possible for people to be the overseas citizens of India if they are of Indian origin and hold the citizenship of some selected countries like West European or North American countries. So this allows them to easily travel to and from India, but otherwise does not give them the privileges of the people who are complete citizens of India. Then Parliament of India consists of President, two houses, lower or LokSabha, upper or RajyaSabha. So RajyaSabha, it is the upper house of Parliament, and it consists of representatives of states and represents the federal character of the constitution. The membership of state is based on the population of that state. The maximum strength of Rajya Sabha is 250, Of these, 238 represents the state and union territories, and remaining 12 are nominated by the president from amongst persons who have distinguished themselves in the field of literature, art, science, or social service, and so on. So 12 are nominated by president, and 238 represents the state and union territory. So it members are elected by the members of state legislative committee assemblies of the states on the basis of proportional representation through a single transferable vote. So they can send their representative to RajyaSabha. Tenure is RajyaSabha is a permanent body and not subject to dissolution. So 1/3 of its members retire every 2 years, and the members are elected by the elected members of the state legislative assemblies, as we have seen just now, for 6-year term. So there is 6-year term, and there are no seats reserved for scheduled castes and tribes in Rajya Sabha. Are near about same, but the age limit is like not less than 30 years. So 30 years is the minimum age to be qualified to become the member of Rajya Sabha, and then registered as a voter in any parliamentary constituency. Then next come the chairman and deputy chairman of Rajya Sabha. So the Vice President of India is the ex officio chairman of the Rajya Sabha. We know it. There are many things we already know, but still, he presides over the proceedings of the Rajya Sabha, and in his absence, the deputy chairman of Rajya Sabha presides over, and this deputy chairman is elected by the members of the Rajya Sabha amongst themselves. Now, LokSabha is lower house of the parliament, consists of representatives elected by the people on the basis of universal adult franchise through a secret ballot. And the constitution prescribes a membership of not more than 530 representatives of the state and not more than 20 representatives of the union territory, and not more than 2 members of the Anglo-Indian community nominated by the president. Now, if in the opinion of the president, the Anglo-Indian community is not adequately represented in Lok Sabha, so the constitution empowers the parliament to, read just the seats in Lok Sabha on the basis of population after every census. And the tenure is 5 years, and it may be dissolved earlier by the president. And the 42nd Amendment Act 1976 extended the normal life of the Lok Sabha to 6 years. However, the 44th Amendment Act 1978 has set it again 5 years as the original constitution envisaged. Now, the life of Lok Sabha can be extended by the parliament beyond the 5-year term when a proclamation of emergency under Article 352 is in force. So the parliament cannot extend the normal life of Lok Sabha for more than 1 year at a time. But in any case, such extensions cannot be continued beyond a period of 6 months. And after the proclamation comes to an end. Now, what are the qualifications for a member of Lok Sabha? So, in order to be a member of Lok Sabha, a person must have, such qualification, citizen of India, and the minimum age limit is 25 years, and registered as a voter in any parliamentary constituency. Then Speaker and Deputy Speaker of Lok Sabha. So Speaker is the chief presiding officer and elected by the members of the parliaments among themselves. And this Deputy Speaker performs the duty of a speaker in case of vacancy or his absence. or her absence. Then Speaker and Deputy Speaker remain in office as long as they are the member of the House. So Speaker continues in office even after dissolution of the House till the newly elected Lok Sabha is constituted. So this is important. And Speaker and Deputy Speaker may be removed from their office by a resolution of the House after serving 14-day notice to them. If this House is not satisfied, or in case of any allegation on Speaker or Deputy Speaker, they give 40-day notice to them, and a Speaker can exercise his casting vote in case of tie, that is in case of equality of votes on a bill. So if Speaker possesses certain powers that do not belong to the chairman of RajyaSabha, and those powers are to preside over a joint sitting of houses of parliament, power of certification of a money bill or the budget when transmitted from LokSabha to RajyaSabha, then whether the money bill is final or not. So, and some special powers of Lok Sabha as compared to Rajya Sabha. The Lok Sabha enjoys the following powers that are not available to the Rajya Sabha. That is, a confidence or no confidence motion can be initiated and passed only in Lok Sabha. And money and financial bills can be introduced only in Lok Sabha. It controls the pursuit of the government. So Rajya Sabha cannot reject or amend a money bill by virtue of its legislative power. So it can only recommend changes in the money bill and can delay it and that is also to a certain period, maximum 14 days. So Lok Sabha enjoys full legislative power in this regard. And under Article 352, Lok Sabha is in a special sitting can disapprove the continuance in force of national emergency proclaimed by the president. So in such a case, president shall revoke the national emergency, and generally meets the 3 sessions in a year. The budget session, which is from July to March, may extend up to April. Then monsoon session, July, August, and then winter session, November, December. Now, the president can call a joint sessions of the two houses if a bill is passed by one house is rejected by the other house. And if the amendments proposed to a bill by one house are not acceptable to the other house, or a house does not take any action on a bill, so remitted to it for 6 months. So decision is taken by a majority of the total members which are present. Now, important terms in parliamentary proceedings. There is a question hour when the first hour of the business of the House is devoted to question every day and is called the question hour. Then adjournment motion. An adjournment motion is an extraordinary procedure which if admitted leads to setting aside the normal business of the House for discussing a definite matter of urgent public importance. Then call attention motion. A member of parliament may, with prior permission of the speaker, call the attention of the ministers to any matter of urgent public importance, and the minister may make a brief statement or ask for a time to make a statement at a later hour or date. And there is a no confidence motion which is moved by a member to express lack of confidence in the government for any reason is called no confidence motion. And if this is motion is allowed and debate the motion, if allowed, is debated, then and at the conclusion of the debate, a vote of confidence is sought by the government. And if it fails to get the required majority of votes, the government has to resign. Then there are parliamentary committees. The work done by the parliament varies not only in nature but considerably in volume too. So a good deal of its business is transacted by the parliamentary committees. So there are ad hoc base or standing committee. As the name suggests, ad hoc committees are appointed for a specific purpose. So they ceases to exist once the task is completed, and they submit their report. And the main ad hoc committee are the select and the joint committees on bill. And apart from ad hoc committees, each House of Parliament has standing committee, such as Business Advisory Committee, Committee on Petition, Committee on of Privileges, and the Rules Committee, and others. Now, other committees are acts as a parliament's watchdogs over the executive. So these are committees on subordinate legislation, government assurance, estimates, public accounts, and public undertakings. And departmentally related standing committees are also there, we call DRSCs. Then Attorney General. Attorney General is the first law officer of the Government of India, and he is the primary lawyer in Supreme Court of India. So he must be a person qualified to be appointed as judge of the Supreme Court. He must have those qualifications. So AG, which we call Attorney General, is appointed by the President of India under Action Article 76(1) of the Constitution, or he or she holds the office during the pleasure of the President. So his duties are to advise government on legal matters and to perform other legal duties which are referred to or assigned to him by the President, and to discharge the functions conferred to him by the constitutions. And though he is not the member of the cabinet, he has the right to speak in both the houses of the parliament or any committee thereof. So, but has no right to vote, because he is not elected by some house. So in performance of his official duties, the Attorney General shall have the rights of an audience in all the courts in the territory of India. He can has that right of an audience in all the courts of in the territory of India, in any state, any territory. So Attorney General represents the government but is allowed to take up private practice, and provided the other party is not the state. So due to this, he is not paid a salary but a retainer to be determined by the President. So the Attorney General gets a retainer equivalent to the salary of a judge of the Supreme Court. Then the Controller and Auditor General, this is again a very important post, which is again appointed by the President, and he holds office until the age of 65 years or at the expiry of 6-year term, whichever is earlier. Here, whether 65 years he completed earlier or 6 years, so depending upon that. So he is the guardian of the public purse. His duties are to keep the accounts of the union and the states, that we call CAG. Also assures that no money is spent out of the consolidated fund of India or the states without the sanction of the parliament or the state legislature. So constitution contains provisions to ensure impartiality of the office and to make the executive. So that's why this post has created, and it is important. So but he can be removed from his office only on the grounds of proved misbehavior or incapacity in the same manner a judge of a Supreme Court is removed. So his salaries and condition of service cannot be changed to his disadvantage during his term of office, except under a financial emergency. So his salary is charged on a consolidated fund of India and is not subjected to vote of the parliament. And it is equivalent to the judge of the Supreme Court. Now UPSC, that is the Union Public Service Commission. This is the India's central agency authorized to conduct civil services and many other exams. And the agency charter is granted by the Constitution of India under Article 315 and 323 of Part 14 of the Constitution, titled as Services under the Union and the States Provide for a Public Service Commission for the Union and for each state. So this Royal Commission on Superior Civil Services in India, under the chairmanship of Lord Lee, and which submitted its report in 1924, recommended the setting up of a PSC, that is the Public Service Commission. And this led to the establishment of the first Public Service Commission on October 1st, 1926, under the chairmanship of Sir Rose Barker. So remember this, the establishment of first Service Commission on 1st of October 1926 under the chairmanship of Sir Rose Barker. Now the limited advisory functions accorded to the Public Service Commission and continued stress on this aspect by the leaders of our freedom movement resulted in a setting up of this Federal Public Service Commission under the Government of India Act 1935. So this became the UPSC after independence, and it was given with the promulgation of Constitution of India on 26th of January 1950. And this commission consists of a chairman, 10 members, and terms and condition of service of a chairman and members are governed by UPSC regulations 1969. So under those provisions, under those rules and regulations, other members and chairmen are appointed by the President of India, and every member holds this position office for a term of 6 years or until he attains the age of 65 years, whichever is earlier. So, and other government departments, the retirement age is 60, but in some cases, like this CAG or this UPSC, the retirement age is 65. Now, executives at the state level, so they have been modeled on central pattern too, and it consists of a governor, council of ministers, and chief ministers. Now, governor is the executive power of the state is vested in governor, and all the executive actions of the state have to be taken in the name of governor. So you can say a governor is just like a president, and chief minister, the duty, responsibilities, and powers of chief minister more or less like a prime minister. A prime minister holds the nation, and the chief minister holds the state. So all the executive actions of the state have to be taken in the name of governor. Normally, there is a governor of each state. However, it is possible to appoint the same person as a governor of 2 or more states. So he can look after more than one state, so you can say. Appointment, term of office, and qualification. So governor is appointed by the president, and he can hold the office during the pleasure of the president. And this is the tenure period is 5 years, and he can relinquish his office earlier by tendering his resignation to the president. And president also can remove him before the expiry of his term, and the government can be given charge for more than one state, as we have seen. The qualifications are more or less same as the president. Minimum age 35 years, citizen of India, and should not be a member of either house, parliament house, or state legislature, and must possesses the qualification prescribed for membership of a state legislature, and must not hold any office of profit. Powers and functions of a government, of a governor, extensive powers, and he is expected to exercise on advice of Council of Ministers, because minister or CM, guide or proposes some bill or some amendments or some advice, then the governor should look into it and prove it. So executive power, because he is the state or head of the state, so all the executive actions of the state are taken in his name, and he also appoints all the important officials of a state, including chief minister, minister, advocate general, chairman, members of State Public Service Commission, as president does in Union Public Service Commission. So there are certain powers. Summon and dissolve state legislature, appoint 1/6 of the member of legislative assembly council, appoint one member from the Anglo-Indian community to the state legislative assembly, give assent to the bills passed by the state legislature, then reserve certain bills passed by the legislature for the assent of the president, and make laws through ordinance during the recess of state legislature. There are certain financial powers. Ensures that budget of the state is laid before the state legislature every year, and all the money bills can be introduced in the state legislature only on the recommendation of the government, and administers the contingency fund of the state and can advance money out of it to meet any unforeseen expenditure pending its authorization by the legislature. Some judicial powers that consulted by the president while appointing the chief justice and the justice of the state high courts, and appoint judges of high courts below the high court, the session courts or district courts, and power to grant pardon or reprise or remission of a punishment to a person convicted of an offense against the state laws. And some emergency power, where whenever he is sure that situation has arisen in which the governance of the state cannot be carried out on in accordance with the constitution or provision, then inviting the president to assume to himself the function of the government of the state or any of them. So when the state is placed under president's rule, the governor acts as the representative of the president in the state and assumes the extensive power. Now the chief minister is again, governor is assisted in discharging his functions by council of ministers, majority party in the same assembly, and is appointed by the governor. And he enjoys a term that runs parallel to that of the state legislature. And the CM recommends to the governor the name of Council of Ministers and allocates the portfolios to them. Now, Council of Ministers, any person can be appointed as a minister, but he ceases to be one if he is not elected as a member of the state legislature within 6 months after his appointment as a minister. So this Council of Ministers is collectively responsible for Vidhan Sabha or this legislative assembly. Then Advocate General is first law officer of the state. As Attorney General we have in a country, in a nation. So the office corresponds to the Office of Attorney General of India and enjoys the similar functions within the state. And he is appointed by the governor and holds office during the pleasure of the governor. Then state legislature. Every state consists of a governor and one or two houses. So the legislature is a state either bicameral, means consisting of two houses, or unicameral, consisting of a one house. The lower house is always known as Legislative Assembly, Vidhan Sabha, and the upper house, wherever it exists, as a Legislative Council, Vidhan Parishad. So at present, only 5 states have bicameral legislature, namely Bihar, Jammu Kashmir, Karnataka, Maharashtra, and Uttar Pradesh. And all the other states have only one house, Legislative Assembly. Now, these councils can be created or abolished in a state by parliament under Article 169 by a simple procedure, and Assembly of the state passes a resolution by majority of the total membership of the assembly and by the majority of not less than 2/3 of the members present and voting. So the parliament may approve the resolution by a simple majority basis. Now, the strength of the legislative assembly varies from 60 to 500 in different states according to the population. So this LA of Sikkim has only 32 members, and the members of assembly are chosen directly by the people on the basis of adult franchisee from territorial constituencies in a state, and seats are reserved for ST and SC on the basis of population. And if the governor of a state is of opinion that the Anglo-Indian community is not adequately represented in legislative assembly, he may nominate one member of that community to the assembly as he considers appropriate. Now, tenure is again 5 years, and it may be dissolved earlier by the governor, and terms may be extended 1 year at the time of parliament during national emergencies. Qualification is same as of a LokSabha member, citizen, and minimum age is 25 years and must not hold any office of profit under the same state or central government, and all the other qualification as may be prescribed by the law. Then officers, legislative assembly shall have it has its speaker and deputy speaker elected from among its members. And legislative council, this is the upper house of the state legislature, and contains various categories of members. And popularly, this legislative council is known as Legislative Parishad. So the membership of the council shall not be more than 1/3 of the membership of the legislature, but not less than 40. Broadly speaking, 5/6 of the total members of the council shall be indirectly elected, and 1/6 shall be nominated by the governor. The legislative council is not subjected to dissolution, but after every 2 years, 1/3 of its member retires. Qualification is same as RajyaSabha members. More than minimum age will be 30 years. And others are same. So then we go for Finance Commission. This is set under Article 280 of the Constitution, and it is constituted by President once in every 5 years. So the main function is to recommend about the distribution of finance resources between center and states, and also among the state themselves, And secondly, the principle which govern the grant in aid of the revenues amongst the state out of the consolidated fund of India. Then very important body, Supreme Court. India opted for a unified and a single judiciary and a single integrated system of courts for the union as well as state. Though it has opted for a federal system, Supreme Court stands at the apex of judicial system of India, consists of Chief Justice and 30 other judges. And the Supreme Court normally sits at New Delhi. And Chief Justice of Supreme Court is appointed by the President in consultation with other judges of the Supreme Court and High Court, as he may deem necessary for the purpose. The other judges of the Supreme Court are appointed by the President in consultation with Chief Justice. So, what are the qualifications? So, qualification should be citizen of India, has been a judge of the High Court or two or more such courts in succession for at least 5 years, or have been an advocate of a High Court or two or more such courts in succession for at least 10 years. So, if a judge, then 5 years, if advocate, 10 years. And a distinguished jurist in the opinion of the president. Means your work and your the past performance matters. Tenure, the judge of the Supreme Court vacates his office on attaining 65 years of age, or by resignation addressed to the president, or on a removal by the president upon a resolution passed by both the houses of the parliament and supported by a majority of total membership of that house, and by a majority of not less than 2/3 of the members present and voting on the grounds of proved misbehavior or incapacity. Now, independence of Supreme Court judges. The Constitution has made provision to ensure independence of the judges. Some of these provisions are as follows. The salaries and allowances of judges are charged on the consolidated fund of India, and thus they are not subjected to a vote of parliament. So it's a separate matter. The salaries and other service conditions of judges cannot be changed to their disadvantage during their tenure. And Constitution Article 124 and 217 deal with the appointment of judges of the higher judiciary. So according to these articles, the judges could be appointed by the President of India after consulting the Chief Justice, CJI, or other judges. So the present system for appointment of judges that was adopted in 1993 is also known as collegium system. So this is called the collegium system. Now, once appointed, a judge of the Supreme Court can only be removed from office by the President or on the basis of resolution which is passed by both the houses of the parliament and with a majority of total membership. And it should not be less than 2/3 of the members present and voting in each house, or there is approved evidence of misbehavior or incapacity of judge in question. Now, jurisdiction of Supreme Court is 5-fold, and first is original jurisdiction. The original jurisdiction of the Supreme Court is purely federal in character, and it has exclusive authority to decide any dispute between the center and one or more states, and between two or more states. Then writ jurisdiction. Article 32 confirms jurisdiction on the Supreme Court to enforce the fundamental rights. So the power to issue writs for the enforcement of the fundamental rights is given by the Constitution to the Supreme Court and High Court. And appellate jurisdiction is Supreme Court is the highest court of appeals, and its writ and decisions run throughout the country. So he is the supreme power. Advisory jurisdiction under Article 143 of the Constitution. This Supreme Court renders advice to the President on any matter of law or fact whenever he seeks such advice. Whenever President asks, they have to give. However, the advice is not binding on the President. Then revisory jurisdiction. Supreme Court under Article 137 empowered to review any judgment or order made by it with a view or to remove any mistake or error that might have crept in the judgment or order. Then there is a High Court. It's more or less same. Now we'll see Election Commission. I'll take a few more minutes because only less 1 or 2 pages are left. So if your teacher joined, please let me know.
Ma'am, that class is not there, ma'am.
Oh, okay. So I'll take a few more minutes. Then Election Commission. The Constitution provides for an independent election commission to ensure free and fair elections. Now, Election Commission consists of Chief Election Commissioner and such other commissioners as the President may decide from time to time. In October 1993, the government promulgated an act which provided for the appointment of election commissioners. So at present, there is a Chief Election Commissioner and 2 other election commissioners who are appointed by the President for 5-year term. The term can be cut short on account of resignation or removal by the President on the same grounds. So the functions of an election commission is to superintend, direct, and control elections to the Parliament and other state legislatures, and to conduct election to the post of President and Vice President, to lay down general rules for elections, to determine constituencies, and to control the preparation of electoral rolls, then allot symbols to the recognized political parties, then to settle any dispute arising in connection with the elections, then to conduct the counting and declare the result. Now, to postpone or counter an elections for a specific reason, they can have the power to do so. Then the Panchayati Raj institutions. The Panchayats are the unit of this whole system. So Panchayati Raj is an important feature of Indian political system, which ensures direct participation of the people at the grassroots level. After independence, the framers of the Constitution decided to give them importance, and under Article 40 of the Directive Principles, directed the states to organize village panchayats as unit of the self-government. So a number of committees were appointed, such as Bal Vantre Mehta Committee, Ashok Mehta Committee, to suggest measures for improvement of working of Panchayati Raj institutions. So Balwantrai Mehta and Ashok Mehta Committee. The Constitution passed the 73rd and 74th Amendment Act 1992, which were related to the working of panchayats and municipalities. So apart from mandatory provisions for reservations of SC, ST and women, there are voluntary provisions for reservation of members from backward classes also. So the Ministry of Panchayati Raj was created in the year 2004 to look after ongoing process of decentralization and local governance in the state. So this constitution envisages a 3-tier system of panchayats and the village level, then the district panchayat at district level, then intermediate panchayat which stands between the village and district panchayats. So in those states where population is above 20 lakhs. So it depends village level or district level on at intermediate panchayat. So all the seats in a panchayat are filled by the people chosen by the direct election from the territorial constituencies in that particular panchayat area. And electorate is named as a Gram Sabha and consisting of a people registered in the electoral rolls relating to a village comprised within the area of the panchayat. And seats are reserved for SC/STs and also for women. And a state may, by law, make provisions for similar reservation of the offices of chairpersons in panchayats at the village and at other levels. And the chairperson is elected according to the law passed by the state. And the duration of this panchayat is also continued to for about 5 years from the date of its first meeting, and it can be dissolved earlier in accordance with the procedure prescribed by the state. Then the qualifications of membership. So all the people who are qualified to be chosen to the state legislature shall be qualified to be chosen as a member of panchayat. And the difference is that the person who attains the age of 21 years will be eligible as a member of panchayat. So minimum age is 21 years. Powers and functions of panchayat. So state legislature have the legislative power to confirm on the panchayat. So such powers and authority as may be necessary to enable them to function as an institution of the self-government. So their responsibility is preparing plans for economic development and social justice, then implementation of schemes for economic development and social justice, then the matters which are listed in 11th schedule, and this schedule contains 29 items. For example, land improvement, minor irrigation, animal husbandry, fisheries, education, women and child development. So a state may by law authorizes a panchayat to levy or to collect and appropriate taxes, duties, tolls, and so on. So at village level, they are an important body for the development and for taking care of all the issues. So a state election commission consisting of a state election commissioner, uh, which is appointed by the governor to conduct the elections of the panchayat. Now, any questions with respect to the elections shall be referred to such authority as the state legislature may provide by the law. So, courts will have no jurisdiction in this matter. Then, municipalities, again, they are an institution of the self-government in urban area and are called municipalities. Three types are there. Nagar Panchayat for a transitional area that is being transformed from a rural to urban. You can say a town type. So that is the Nagar Panchayat. Then municipal council for a smaller urban area. Then municipal corporation for larger urban area, like the big cities. So the composition of municipalities generally it is again elected by the direct election, and the legislature by law provide for representation in municipality. So for one or more wards comprised within the territorial area of a municipality having a population of 3 lakhs or more, and it would be obligatory to constitute ward committees. So duration again it is of 5 years, and it may be dissolved earlier according to law. And qualification, again the minimum age is 21 years. Now, 20 minimum age 21 years for the member, and while for election to the state assembly, the minimum age is 25 years. Then the union budget under Article 112, there is always an annual financial statement of the government. And this bill and is classified as a money bill, and it is presented to the LokSabha upon the recommendation of the president. And this is the statement of the estimated receipts and expenditure of the government of India for following financial years. So all the expenditures approved through various demands for grants and expenses charged on the Consolidated Fund of India are then presented in the form of a single bill called the Appropriation Bill. And this proposal for taxation to raise a revenue are presented in the form of financial bill. So what is the difference, appropriation bill and financial bill? The taxation to raise the revenue is financial bill, how to gain the or raise the revenue, and then what to be what are the expenses or grants, and what to be given to fund to be given to various institution or ministries or sectors for the development is appropriation bill. So consolidated fund, it is the fund to which all the revenue, loans raised and income of the government of India are deposited. So that is the consolidated fund of India. And charged expenditures are the expenditures that do not require the approval of the parliament to be spent out of the consolidated fund of India. So, and then there is a contingency fund. So this fund was created in 1950 by an act of parliament on the basis of powers provided under Article 267. And it has the limit 50 crores. So it is placed at the disposal of president to meet unforeseen expenditure where the parliament's approval cannot be obtained owing to time factor. So president is, you can say, the in charge of that fund. Then public account of India, it accounts for flow for those transactions where the government is merely acting as a banker. So this fund was constituted under Article 2662 of the Constitution. Examples of those are like provident funds, our savings, and so on. So these funds do not belong to the government. They have to be paid back at some time to their rightful owners, that we are like deposit our money in various schemes in banks. So because of this nature of fund, but this fund or that money is again used by the government for various schemes. So because of this nature of the fund, expenditures from it are not required to be approved by the parliament. Then there is important Ayog, important commission, NITI Ayog. NITI Ayog is National Institution for Transforming India, NITI. Is a policy, it is a think tank of government that replaces planning commission and aims to involve the states in economic policy making in India. So this is a very important body which directs the government for economic policy making. So it will be providing strategies and technical advice to the central government and state government. And the government had announced the formation of this Ayog on 1st of January 2015. And it has the following levels. The Prime Minister of India will be the chairperson, and governing council comprising the chief ministers of all the states and lieutenant governors of union territories. And regional councils are also will be formed to address specific issues and contingencies impacting more than one state or a region. So these will be formed for a specified tenure. Now there are some experts, some specialists and practitioners with relevant domain or relevant field of knowledge. So they are the special invitees, will be nominated by the Prime Minister. So this is all about your this higher education. I think I have covered all the topics. Now, if you are having any doubt or any question, so you can ask.